There he is again. Good morning, sir. Are you John Reading?
Yes, sir, I am. How are you this morning?
We're ready to go. Set that energy drink aside. We'll pretend
sir.
like we're at work and we'll get started. Donna Brown is here with me in the courtroom, and you're here by Zoom, which is acceptable for this first pretrial. Let me call the case. It's 251969GC. It's entitled Donna Marie Brown versus John Paul Reading. We've had some previous cases. We had at least one with these parties in this court. I think there have been some actions in some other courts here. And this is a new general civil case. Plaintiff claims substantial damages. She caps them at $25,000 to keep the matter in the district court. District court has jurisdiction over general civil matters up to $25,000. It's $25,001. It must be removed to the circuit court. So am I correct, Ms. Brown? You're capping your request for damages at $25,000.
Yes, sir.
There are multiple claims. I've got, this file is already this fat and we haven't even started yet. This morning, I received a pleading from the defendant entitled Defendant's Motion for Summary Judgment to Dismiss for Lack of Subject Matter Jurisdiction under 2.116C4 and 2.116C8. And I haven't had a chance to really review it, and I haven't had a chance to deal with it. And the defendant filed it, but the plaintiff just got a copy when I handed it to her about 2 seconds ago. So we aren't ready to address that matter, but this is a pretrial conference. Defendant is here from his address by Zoom. If we do have testimonial proceedings, he'll need to be here in person. The plaintiff has filed a bunch of stuff, including subpoenas and discovery motions and that sort of thing, some of which may be a little bit premature. The general rule in district court civil matter is there's no absolute right to discovery. And subpoenas don't just get issued willy-nilly. They cause a lot of work at the other end. So, Ms. Brown, you filed this action. You capped it at $25,000. What are you asking me to do here?
Your Honor, I'm looking for relief in this case. There was a contract in good faith between Mr. Reading and I for the children's enrichment, and I have paid for it, and Mr. Reading has stopped paying his contractual obligation. I did just recently submit a motion in to add on exhibits. I tried to follow the process because of the cutoff point, but this information was obtained through some of the other subpoena records in one of my other cases with Mr. Reading, where it does show that Mr. Reading was upholding the contract.
Now, you're talking about this contract. Is that in here?
Yes, Your Honor. Exhibit 1.
Okay. Zach warned me about this. This is a family law matter. This isn't a straight contract action for district court. Good Lord, what a mess.
This was outside of our friend of the court agreements. This is solely in good faith to pay for the lessons and enrichment for our daughter.
And one of the issues is whether this is jumping jurisdiction from the friend of the court to a general civil case. This happens in domestic relations case.
Yeah, I remember now. I need to find that video. These people are these people are out there.
Cases, people are unhappy with a ruling in domestic relations. They file a small claims case, or they file a general civil case when the actual jurisdiction lies with the family court. So I can't tell.
This is for extra activities that were quite expensive. It was never part of any of our, it was never even requested in front of the court because it was.
The argument is it should have been, that it should have been part of the front of the court action. It had to do with custody of the children, support of the children, enrichment of the children, and it should have been part of an order. I don't know that that's true, but that's the argument. There's so much stuff in here. I'm looking for the actual exhibit.
Mr. Redding was paying on this in Exhibit 8 that we can see outside of any friend of the court. He was making payments directly to me within this contract.
This contract, Your Honor, that's not a contract, it's Exhibit 1. It's just a note. And it's an explanation that she asked me to write to front of the court. I even write in there, I live in separate units of the house. So I'm not sure why she believes it's contract, but.
Well, I'm trying to even find it.
Okay, this is crazy. It's not a contract. She's just trying to harass him outside of family court here. Hopefully he kicks it. I don't know. We'll see.
She filed a pleading. Why this matter belongs in district court, not friend of the court. This is it. To whom it may concern, I verify that I am responsible for Kaylee Redding's dance and horse lessons per our custody arrangements. I pay Donna Brown the cash reimbursement for these activities, also assist with transportation mileage or payment of out-of-pocket expenses associated with John Reading's medical expenses per the custody agreement. Donna is able to pay me bills out of this money. Not sure what that means. We live in separate units of the house and are separated through the courts, taxes, child support in place. Signed John Paul Reading. This document doesn't have a date on it. So she's suing on contract Exhibit 1.
I'm stating, Your Honor, this is a note that she asked me to write to the state because she was on state benefits and she didn't want to be disqualified. Hence the extra explanations in there. This is not a contract.
Defendant contends it is not a contract. But a note to the state.
Your Honor, if we could see Exhibit 8, it can show that Mr. Redding has been paying on this contract, and what he said is not true.
All right, he may have been paying it on a note. Well, so the first question is, it is a contract. Contract has offer, acceptance,
Consideration.
an agreement that's only signed by one party. So there's a fundamental question about whether this is even there's several issues. One, should this all be under front of the court?
Yes.
Two, is this a contract?
No.
It's a note to whom it may concern.
This is an easy one.
It's only signed by one party.
I'm not even breaking a sweat with this.
This is a good faith, Your Honor, agreement between us with a promise, and I acted based off of this promise and put the money out for our child's activities. And if you could hear this case, Your Honor.
And I will say she knows this belongs with front of the court with anything she's requesting. That's why she even tried to get in front of that before. But in the motion that I filed for judgment to dismiss, I kind of basically put that it lacks proper subject matter. It lacks material terms such as duration, price, payments, lacks clarity and specificity. I mean, it doesn't even have her signature. It's not even a contract. This is literally for her to get state benefits. And she's trying to use it later. She's literally trying to harass me and my wife. The last judgment she sued us me over something that had a $0 balance by the time insurance hit it. She didn't want to provide insurance. So she's been using the child support.
I hate to say it because this guy's also kind of hard to like, to be honest, but she's just jealous and needs attention. It's that simple. That's all that's going on here.
Reasoning case to get subpoenas to get my wife and my bank records.
I object.
All
Well,
right.
she submitted
let
it all
me
there.
finish.
It's all there. She submitted literally everything.
All right. First of all, was this guy actually stupid enough to get married again? Apparently, yes. And now, are you trying to tell me that he lives in the same house, although a separate unit with his wife and his ex-wife? Sorry, John, but that is the dumbest idea I have ever heard in my life. I cannot imagine. I cannot imagine the hell of an actual wife and ex-wife living in that proximity to me. No.
Thing that has nothing to do with anything, just to harass myself and my wife.
I object.
Okay.
So noted.
Well, he disagrees with you. You have a theory of your claim and he has a different theory. He objects to your claim and you object to his pleading. Right now, he's filed very late in the game a motion to dismiss under summary disposition. If he prevails in that matter, the case is over. If he doesn't prevail, then we can go further ahead. But I can't deal with this because you just got notice 1 minute ago. I don't expect you to come in on the fly and answer his motion for summary disposition. So I'm going to adjourn this for 21 days to give you an opportunity to respond to his motion for summary disposition. And then the second, if we get past summary disposition, there's a fundamental question about whether this is even a contract upon which you can sue. I'm not signing any subpoenas until we get further in this matter. Subpoenas are intrusive. They cause a bunch of work at the other end. They can be a form of harassment. Subpoena this, subpoena that.
Your Honor, the one subpoena was for me against my own employer because of the job loss caused by Mr. Redding and his wife. I know that they had falsely said some things last time in court about her.
Well,
about
I
her
dealt
job,
with some of this at the
but
earlier
this was
hearing.
evidence. That's what I was trying to obtain, actual evidence, not making false accusations as they have.
Okay, that's better. He's in another state. God bless him. I thought that this guy was going to try to live next to his ex-wife with a new wife. Oh my God.
Your Honor, Mr. Redding is very behind in child support, over 14,000, and the subpoenas were, the other subpoena is used to show that he has the means and capacity to pay, but he has not been honest to the courts. And I'm asking.
That's not this case.
Correct.
You can't use a subpoena in this case to prove that he's not paying your child support.
No, this was to show that he had means and capacity to pay.
It's still not this case. It doesn't matter whether he has means and capacity to pay it. That starts if you get a judgment and then you attempt to collect on it.
Yes, Your Honor.
But right now, he filed this last second motion, which isn't fair to you to have to respond to it.
Okay.
So let's continue this.
To clarify, Your Honor, that's only like 5 or 6 months of child support. I mean, I know this is being live streamed, so.
Say that again. I didn't understand you.
This is only about 5 or 6 months of child support, and I've still been making like very low $150, $200 a month payments towards her. It's not like I've not been paying child support for years. It's just for jobs where you're paying almost $2,000 a month in child support. It takes a little bit of time, panel interviews.
Yes, this is a child support case that is
Yes, Your Honor.
lapped over into general civil. And that happens, as I said, from time to time. Let's see if we can find a place to put.
If you could look at Exhibit 8, though, you'll see that he was paying on this separately in this agreement. So,
And I don't,
Yeah.
I think that probably is accurate.
Well, if I'm paying on something when we're all living together in the same household, I mean, that's a different
Well,
story.
one
than-
problem is that this thing doesn't have a date on it. I don't know if it's pre-order or post-order or,
our child support orders were done back in 2015 and 2020. This signature was in 2023 by Mr. Redding. Additionally, when they move out of the house, this was a contract in good faith between us that it was not brought up to friend of the court for any matters because Mr. Redding was paying on these things prior. And
it should have been. You're backdooring the friend of the court by some sort of document that you call a contract. The friend of the court has jurisdiction over child support and these sorts of issues. And you're claiming that outside the knowledge and belief of the friend of the court, that he agreed to this contract. We'll have to figure that out.
Yes, sir.
Today is
She
January
submitted
26th.
She submitted all this to the front of the court, and they thought it was unreasonable that I pay $20,000 a year for a child to have a horse and do extravagant activities. If I choose to pay that when I'm living in the house, it has
That's
nothing to do with
correct.
anything here.
Your Honor, this has never gone to the friend of the court because Mr. Redding was just paying on it. And that's why I made the decision to keep our child in an activity that was really helping her.
Okay.
All right, finding a place to put this is a little problematic. 21 days would get us into February 16th as a government holiday for President's Day, I believe. I'm gone Monday the 23rd.
Your Honor,
Yes,
if we could, since Mr. Redding and I have multiple things going on, the only way for me to collect is when we sell the house. Mr. Redding has not been paying on the house, and so I'm trying to partition that and push that through with Judge Pattison.
and
So
Judge
any-
Pattison has that case,
Correct. If
yes.
any judgments were to come from this, that would probably be my only window to collect from Mr. Redding. So if the soonest date possible, to try to push this along so that it could go in combination with.
She said a lot of stupid things, but that actually is wise. I mean, it's not really the judge's problem on your potential collection action in the future. I don't think this claim has merit, but she's like, it only matters if we get this judgment on file prior to the sale of the house, and she's probably correct.
Our other cases, Your Honor.
All right. Well, I can rule on it right now, but you just got it. So I'm adjourning this for your benefit. So I'm trying to find a time to put this.
Yeah, he can rule on it right now, but you're not going to like the ruling. I've heard enough. I know where he's at.
The Zoom hearing,
But we
something
missed
for,
two Mondays in February.
Thank you.
Your Honor, Zoom hearings for the rest of this possibility, as I live in Texas.
Yes, this next hearing will also be by Zoom. I'm trying to set it as soon as I can, but there's already stuff set. The 16th of March is not within 21 days. 16th of February, excuse me, that's a Monday, but we're closed that day. So the next possible day would be the 23rd, and I won't be here that day. So that takes us to March 2nd. Which is crammed.
Oh, I remember this now. Thank you, Zach. I put a link to the prior video in here. It's called Karen sues dad for providing insurance. That's exactly what she did. Oh, it was so annoying. Anyway, there's a link to that video. Same couple. I don't know when it's from, but it was a while back. In the description.
Full. So I'm going to continue this to March 9th. (2026) at 9:20. You're welcome to come in live or by Zoom. Block 9:20 to 10:30. We'll have more than an hour if we need it. You've got a number of things that you filed, motions, and some of these are not controversial. For example, leave to file supplemental exhibit lists. I won't have a problem if we get that far to allow you to file additional exhibits and witnesses. But the motion that he filed is dispositive. If he prevails, the case is over. And you haven't had a chance to respond to it. So you have 21 days from today to file a response to his motion for summary disposition. You don't have to file a response, but you have a right to. Unfortunately, 21 days would get us to March or February 23rd, which would be a good day, except I'm not here. So the next available space is March 9th at 9:15. He claims lack of subject matter jurisdiction, promissory estoppel, alleges that all child expense disputes should be made with the friend of the court, not the district court, and some other things. So we're on hold pending ruling on those motions. So that's really all we can accomplish. If you have any additional motions you wish to file, notice them out for that same date, March 9th. All right, that's, I guess, all we can accomplish at this point. I've reserved on all the motions that the plaintiff has filed. As I indicated, some of them are not very controversial. Should be easy if we get that far to rule on. But the defendant's motion for summary disposition cannot be heard this morning because the defendant hasn't had a chance to respond. Plaintiff hasn't had a chance to respond. So the entire matter is continued to March 9th at 9:20 a.m. We'll rule further on it. Are there, the partition matter is still pending in front of Judge Pattis, is that correct?
So initially I had put that in a petition back in 2024. It went through. Mr. Redding had it dismissed based off of our rights to survivorship.
He is granting this motion all day long and throwing this back to Pattison, which is the right call. I mean, I don't know, but for all the world, I can't see it going any other way.
During our personal protection order hearing that I was able to get against Mr. Redding. Judge Pattison told us that it would be best if we changed the deed, so then we could repartition. So we agreed to change the deed to remove the rights of survivorship so that I could put it back to petition to get Mr. Redding to sell. Our attorneys were working on that together, and just on Friday at the very end of the day, now Mr. Redding has filed something, even though our attorneys were working together to try to move this forward. So I really don't know. What the
I do
steps is,
believe
because
at some point that property is going to have to be
it has to be sold. Yes, Your Honor. I've been trying to do
for
that.
everybody's interest right now.
Absolutely.
Damn, you may kiss your bride.
It's in limbo,
Mr.
but-
Redding's not paying on it, and it's really a
Well,
financial burden to me.
I
All right, well, I'm
filed
not in
that.
that case. I know Judge Pattison would like to get that
Right.
case over the finish line.
Yes, Your Honor.
Well, in her last request, she wanted me to pay for her and her new husband to live in the house that I co-own, and that's the reason why I didn't. I got part of why I got it thrown out last time, and then she said she was going to file and then didn't.
All right, I'm not getting dragged into that
Sure.
tar ball. I'm going to deal with this. At any rate, the whole thing is adjourned to March 9th, 2026 at 9:20 a.m. You have 21 days to file a response to his motion for summary disposition. And if you have any additional motions you wish to file, you can notice them out for March 9th at 9:30 a.m. I'm not going to rule on any of your other matters until that time. I'm not going to sign any subpoenas or anything further until the pretrial and hearing on motion for summary disposition. All right, Mr. Reading, anything further?
That's all, Your Honor.
All right, Ms. Brown, thank you. I know it's hard to get out today. School's off, freezing cold. You're welcome to be here live every time. You're also welcome to come by Zoom. Mr. Reading, I'm going to excuse you.
Stay strong, John. It'll be over at some point. I don't know. Might be 12, 15 years from now, but at some point this hell will end. You went and volunteered for more hell. I can't help you there, my man. I can't. That wasn't good thinking, but I wish you well.
Ms. Brown, you're free to go. I'll see you on March 9th.
Thank you, Your Honor.
Your Honor.
All right, our next matter is at 10, I believe. As I indicated, I'm double booked on criminal sentences. We'll deal with those in a bit. I do have a Polycom. Is Miss Jackson still here?
She was when I walked in here. If she's left since I've been here, I'm sure.
Would you check and see?
Yeah, I can check. You want to see her? She's still.
Yeah, I could use her help. If I can get a public defender, perhaps I could do this bench warrant arraignment I got.
So today, if you're in jail in Acapias, and today, if you are, consider my decision. If I do release you today, again, on the first business governmental assistance, Attorney General child support statement, just remember to ask a judge or bailiff for that information. Any plea of guilty or decide you don't want that conviction, you may submit a written and get you taken care of. I'm going to start with Mr. Laro. Come on up. Okay, so again, Mr. Laro, I show that you pled on September 15th, 2025 to several cases. You had 5 cases that you set up, then you got out of jail, you set up a payment plan.
Yes, ma'am.
Right? And then you didn't make any payments. Why did you not make any payments on your payment plan?
So I lost my job.
Why did you not come back to court and talk to the judge about it?
My car's broke down, Judge. I have to get rides everywhere I go. So I mean, it's kind of hard. I've been taking care of a friend of mine that's got stage 4 rectal cancer, or she's got 4 kinds of cancer, but she's got stage 4 rectal cancer. So it's been hard to get out and
Well,
have
what?
some with her.
Yeah, but Mr. Laro, it wasn't hard to get out yesterday.
I finally got my car running yesterday. After
Yes.
a year and
Yesterday was the first day since you stopped making payments in September.
that my car's running, yes, ma'am.
I'm struggling with that, Mr. Laro. You know, do you have a cell phone?
Yes.
I'm struggling with that. Otherwise known as I don't effing believe you. Not for 1 second.
Does it have data? Like, can you look up the internet and stuff on it?
The
Yeah.
night version.
Okay. How come you never wrote to the court? You never requested virtual court, anything like that?
You know, I can do that. In virtual court, if I already played, I didn't know I should do that.
Okay. Well, I'm looking at your pending warrant letter. It says that you could, if you cannot bring your payment plan current within 10 days, this is what we sent you back in October, okay? If you can't make your current payment plan current within 10 days, you must appear and speak with the judge before the 10th day. You may appear in person at any walk-in court time or complete the virtual request form online, and it has a link for you where you go to request a virtual docket via Zoom, and they even tell you when you could appear. So I don't think that you opened your mail or did anything to try to resolve this, sir. That's the unfortunate thing. And then when you failed to respond to that letter, then we just set you for a hearing, for an in-person hearing, and you didn't come to that hearing. Now, I know your address because we've already talked about that. And, you know, we have people all the time that come to court that said, yeah, I had to walk, I had to get a ride. So I find it difficult to believe, sir, that you were actually confined to this home since September 15th, 2025 until last night and during a snowstorm at 6 p.m. And you weren't even anywhere near your house, Southwest 15th in South Georgia. So I don't think that you're shooting straight with me, Mr. Laro.
Can I explain?
Sure.
I was out yesterday. I finally got my car running. So I'm sitting for
How dare you, Judge Mom? I can't believe you would suggest that he is being less than honest.
a test drive. When I was on gone.
Taking it for a test drive during a snowstorm. Okay.
No, it's been a year and a half since it's ran.
Okay. So how have you gotten around since then, since the car hasn't run?
Walk.
Why did you not walk to the court?
It's like 5 miles. Can't walk that far. But I can't.
What happened to the city bus system or a friend or Uber?
You have money to Uber.
A 5-mile walk is exactly what this guy needs. Exactly.
How are you paying your bills?
A friend of mine's helped me.
Well, did you tell your friend that you needed to come to court?
I guess I didn't tell her.
Okay. Did you get any tickets yesterday when you were booked into jail?
No, ma'am.
Okay. Well, I'm going to find that you failed to make a good faith effort to resolve your fines and court costs. Your balance is $1,162, and I'm going to give you 1 day jail credit. So your balance now is $1,012. Notify your friend that you owe $1,012. Maybe she'll pay that. He or she will pay that for you. You're free to go back to your pod. Thank you.
Go back to your pod, big liar. I want you to think about what you just tried to say here.
Mr. Ramirez.
Huh?
Hi, Mr. Ramirez.
How are you doing?
I'm good. Hey, you know,
How you doing?
I saw you back in, I lost my notes on you. Hold on. I saw you back in, I think, 2025. And you had some cases that I talked to you about from 2021. And you were like, I don't remember those.
Oh, yeah, I do remember we talked about that.
Do you still not remember those? Or after you left, did you think to yourself, now I remember what she's talking about?
I remember not remembering, Judge, if that makes sense.
I truly don't remember those still to this day.
Okay. I sent those to the prosecutor to review because we talked to the warrant officer that day. Did you talk to Corporal Dickey that day?
I was talking to, because I left and I was supposed to do a payment plan.
Corporal Dickey, I swear, I can't get through a stream without some ridiculous name. I cannot do it.
No, I'm talking about before you even set up the payment plan.
I don't remember, to be honest.
Okay, that's fine. Yeah, you set up a payment plan, and then what happened?
I had paid. I remember I came to jail and I had to pay $1,100 to get out. That one time for them tickets, and I paid $1,100. So then December came up. I have 2 daughters, and I had to buy Christmas presents. I paid my rent. It's $850 plus my bills on top. So it's been kind of hard for me lately. But
then
Christmas presents and drugs, but mostly drugs.
Why did you not come back and see me?
I should have, but I didn't. That's my fault.
And you're kind of in the same boat as Mr. Laro.
Yes, ma'am.
We wrote you letters.
Yes, ma'am.
Okay. All you had to do was come back.
Yes, ma'am. I understand that. That's my fault.
Where do you work?
Palm City Pools. I build pools. My brother owns a pool company. And I'm just barely getting back on my feet.
I don't know. Doesn't really look like you're getting on your feet. Looks like you're chilling in a pod.
Who lives in your household?
My mom, 821 North Highland is my mom's. It's owned.
Okay.
But right now I'm with my lady. I just barely got back with my lady, so I'm at 505 North Hayes.
Wait, didn't I verify your address?
Yes, ma'am. My real address is 821 North Highland. That's where I live. But I just got back with my lady, so it's 505 North Hayes.
Well, where do you want?
It's so romantic. I love how he keeps saying, I just got back with my lady. I got some poor woman who's suckered and will pay for my crap. That's what's going on. There's no other scenario when you describe it that way. There's no other way.
Your mail to go.
821 North Highland. That's the mail. I always get the mail there because my mom lives there, so she will notify me.
Your mom probably thinks you're old enough to be getting your own mail.
Yes, ma'am.
But she's probably too nice to say that to you.
Ooh, mom shots fired right there. She called you immature, my friend. She said you're like a little kindergartner, needs mama to get you her mail.
Well, you owe $12.47. So what's the plan?
Well, I'm trying right now. I'm back on my feet. I mean, I barely started. I got out the hole. I was in a hole for a little bit because of the tickets and then Christmas presents and my bills stacked up. And I already have.
No, but here's the deal, Mr. Ramirez. Here's my problem. We set a payment plan that still would have allowed you to do Christmas.
Yes, ma'am.
And you chose not to do that. You chose, it was supposed to be $75 a week. And so when I see a payment plan of $75 a week, do you know who tells me what payment plan to set? When I set a payment plan that's $75 a week, guess who tells me that's a payment plan that can work? You do. You're the one who would have said, set that at $75 a week, beginning on 12/15. And then you didn't make the payment, and then we sent those pending warrant letters and sent you for a hearing, and you didn't do anything.
My fault, I'm sorry.
Well, I just don't understand. Why didn't you come to court on January 15th when you were supposed to? And if you tell me you didn't know about it, that means your mail is going to your mom's house and your mom is saying,
Yeah, she probably, yeah. It's probably
yeah. So maybe you should get your mail at your own house.
Yes, ma'am.
But anyway, well, you still owe $12.47. I am going to remand you to the chief of police of City of Amarillo until your fines and costs are paid in full. I'm giving you, that's with your jail credit. So you get 3 days jail credit. So your balance is $12.47. Okay. So you call somebody, call your brother, see if he'll get you out.
I'm pretty sure he probably will.
Okay. Okay. $1,247 in full.
All right. Thank you.
No more tickets.
All righty. Sounds good.
Hey, one more thing. Because of those other 3 tickets, I've sent that back to the prosecutor asking her to review that again. You need to kind of be up on that because those tickets have it's the same name, but I think the name Christian is spelled with an H on that one, and it's same date of birth. So you need to be aware that those are out there.
Okay. Sounds good.
Because they're not resolved yet.
All righty. Sounds good.
Okay, thank you.
Thank you.
Yeah, that's great. I'll be ignoring that as soon as I walk out this door.
Am I good to go, boss man?
Mr. Swain. Give me just a second. You have 2 charges. One was at warrant of running a red light from August 1st of 2025. You never appeared on that one, sir. Do you want to plead not guilty, no contest, or guilty on that?
Guilty.
If you plead guilty, I'll find you guilty. You will receive 2 days jail credit.
Guilty.
Okay. Well, actually, you'll be time served. And then you have a no insurance case from the 14th. That one's not at warrant, but you're still entitled to jail credit. How do you want to handle that one? Do you want to plead not guilty, no contest, or guilty?
Not guilty.
Do you have insurance?
Yes, I do.
Okay. That one, I'm going to order you to...
This is the highest functioning defendant I've seen in a long time. He pleads guilty to the one he's clearly guilty of. He's pleading not guilty to one he thinks he has a defense to and probably does. He doesn't waste anybody's time and he answers questions directly. He's like a criminal defendant genius. It's unbelievable.
I'm going to order you to post a $500 PR bond, which means you don't pay any money up front, okay? But you do have to appear. Now, what I would do, the bond will state you have to be here on 1/28 of 26. Come with your insurance card if you can.
Yes, ma'am.
And it's on that 2007 Expedition.
Yes, ma'am.
I'm just curious, what were you doing out and about at 1 a.m. during that horrible storm?
Just got off work and was headed back home.
I see.
I was curious about this. I was bracing. I've seen this. I was bracing for absolute stupidity. But no, He's got a fantastic explanation, and I think it's correct.
Okay. And why'd y'all get pulled over?
He was driving with no headlights when he pulled out a tube and towed him.
I see. Where do you work that you had to be at work on a snowstorm, so like that?
I work for Lone Star Services. I do heating and air.
Oh, well, they probably need you to be at work, sir.
Yeah. Yeah. If any guy needs to be out on an emergency basis in a storm, it's the HVAC guy. That makes all the sense in the world.
So, okay. Okay. Well, your time served on the running a red light.
In fact, get him the hell out of there. The state of Texas needs him right now. People knock these blue collar guys. They make the world run. We owe them a huge debt of gratitude. Get him the hell out of jail so he can go fix heat for the next couple of days because the entire state needs it. Carry on.
You'll need to appear with your insurance card by the 28th. Now, if you want to come in tomorrow, you can. We'll have court at 11 a.m. and 2 p.m. So if it's better for you to come in the morning, you're free to come in. Please come in at 11 a.m. tomorrow if you want.
Okay.
Okay? Okay, thank you. We'll see you tomorrow. Miss Milone. Or you said it differently. Milone?
Milone?
Milone.
Yeah, say it like that. It's like a Bono Michard from the
Got it. Okay.
This one is also shockingly rational. I thought it was going to go crazy. I was disappointed, but it was kind of neat. Both these last two are, I'm like, okay, you did some stuff, but you make all sorts of sense.
Okay. So you received a public intoxication charge the other day. That is Class C misdemeanor, punishable by that fine of up to $500. You can plead not guilty, no contest, or guilty. What would you like to do?
no contest.
If you plead no contest, I will find you guilty. I will assess a fine and court cost, and I'm going to time serve you.
Okay. Yes, Your Honor.
Okay. Okay. So that will be on your record, but it is Class C misdemeanor, so it shouldn't have too bad of an effect on you. Do you have a criminal history from anywhere else?
No, Your Honor.
Okay. I just have to say, what happened to you in that hotel room?
Oh, Your Honor. I've been in a program for alcohol, and when me and my mom were traveling, she was, kind of egging me on a drink with her. And honestly, I don't remember, Your Honor.
Your mom wanted you to drink with her, knowing that you'd been in an alcohol program?
Yes.
Try not to, I don't want to offend you regarding your mom, but
I know.
is she the best accountability partner for you?
That's all I've got, Your Honor. But I do have the VA that's waiting for me in Lorain, Ohio.
Okay, so you're going to Lorraine. Okay.
Yes.
Where's your grandpa live?
He lives in Lorain, Ohio. I don't have the address, but my mother does.
Okay, he lives in Lorraine. Okay. Well, they got a lot more snow than we did. So is your mom still here?
Yes. Yes, Your
Okay.
Honor.
Did they kick her out of that hotel?
Yes.
Yeah,
Yes.
figures. Okay. Okay, well, I wish you guys safe travels, and I wish you much better luck with your recovery. It's okay.
Thank you so much, Your Honor.
You're welcome. Okay, thank you.
Thank you. Does that mean I'm good to go today?
Yeah, you're free to go.
Thank you.
Uh-huh.
Thank you, Your Honor.
Good.
Okay, thank you, Deputy.
Thank you.
Uh-huh. Have a good day.
All right, there you go. I threw a little Judge Mom in there as a bonus. Very, very frustrating. Thanks for sticking with me. Very frustrating when the internet goes out. It's weird because I've streamed a couple times. It's just it's doing that now. And I was like looking around this morning for stuff. And the internet's fine, but it only needs to go out once and it blows up a stream. So we had to start over, but we got through it. We got through the stream. That was good. I didn't realize that. Zach put that together, sent it over to me, which is awesome. And then I start doing it, but I didn't realize it was a case that I'd previously done. So it's kind of cool for me to get an update on them. The update is The ex-wife is still insufferable. I can't say I'm surprised. I'd like to tell you I'm surprised, but I'm not. I'm not. I would have guessed that if you would have given me the option, I would have guessed that. Thanks for coming out. I'll see you soon.